Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Offices and Attorney Codi Dada, founder of the Codi M Dada Law Offices in Novato, California. Recognized as one of the top 10 best law firms in California, Codi focuses exclusively on estate planning, trust, and probate administration. I'm Lisa Mosbey, and today we're breaking down the difference between a will and a living trust in California and what determines whether a family ends up in probate or avoids it altogether. Welcome, Codi. Are you ready to dive in?
Good morning, Lisa. Yeah, absolutely. Thanks for having me here. It's good to see you.
It's my pleasure. And this is a great topic, a great conversation, because I think so many of us wait far too long and we get to that point where we need it and we don't have it. I see it happen all the time. So, where I'd like to start today is with the basics. Can you actually tell us the difference between a will and a living trust? And I have a follow-up question. Are they the same from state to state, or is California unique with their will and trust services?
Well, the difference between a will and a trust are very important to identify and for people to be aware of, because a lot of people think that a will protect them from going through court process. But a will has no legal authority in the real world until someone takes it to court, probate court, and submits it, gets it acknowledged by the court, and receives court order that that person named in the will has authority to manage the assets of the person who created the will. Now, that process to get acknowledged and get that court order is called probate. And in California, we want to avoid that because probate in California is a very expensive, tedious, long process that takes anywhere from 8 to 18 months on a good case. It can take longer if there's issues with taxes and conflicts and identifying assets. So the will is something that you don't want to rely on because of that reason. And the limitation of a will is that it has no effect during your life until someone passes away and goes through this court process. So if you were to become incapacitated during your life, the will is not going to help much. Okay. Now, a trust, on the other hand, is a legally recognized document that doesn't need to be approved or acknowledged by the court. You can go directly to a bank, a financial advisor, real estate company, escrow company, and they will honor that because the way that the law is written is it says that when you put your assets into your name as trustee of your trust, it allows everyone in the real world to follow the instructions of your trust without worrying about getting in trouble, giving authority to the wrong person. See, and that's the difference. Is a will doesn't have any legal authority until we go get a court order and go through this probate process. A trust is a private instrument and it allows you to step in to someone's situation if they were to become incapacitated, unlike a will. And then at that point, the person who's named as a trustee in the trust has a legal duty called a fiduciary duty to do everything in the best interest of the person who created the trust. They would be considered the beneficiary. And so it allows the person to be protected in the event they become incapacitated and they need someone to step in and help them, and also after their life to efficiently distribute their assets without court involvement and therefore avoiding exuberant court fees, filing fees, putting a newspaper ad, sending out notice to all the government agencies, the IRS, Franchise Tax Board, all the legal errors. And it streamlines everything. And so it's very important that people with any type of assets have a living trust established with their assets funded.
And then let's be more specific on what exactly does the will do, or what role does the will play after someone passes away? And when does the court become involved with that process?
So the will is a ticket to probate because it has no effect in the real world until we go and get
Mhm.
it acknowledged. So what a will does is it says how you'd like your assets distributed after your life, but it has no mention about who's in charge during your life if you were to become incapacitated. And the will, like I said, it's a long process because you can't just immediately step in and take charge of the assets and distribute them. First, you have to file, and then you have to wait typically 45 days from the date that you file the petition for probate until the first hearing is 45 days. And then in the meantime, we have to do what's called publication, which means we have to put a newspaper ad that gives notice to the world that if they're entitled to anything from the estate, that they have a certain amount of time to make their claim against the estate. And then we have to serve all the legal heirs and everyone named in the will a certain formal notice that the petition for probate has been filed. And then we have to file a proof of service that we've send it to the court, letting them know that we've given notice and that we've put this newspaper ad. And then oftentimes a bond is required, which is like an insurance policy that the court wants us to place in the event the executor, which is the person named in the will to handle the estate, mistreats the assets. The beneficiaries have some sort of insurance policy that they can get repaid. And so that requires a premium to be paid. And then there's filing fees. And then there's statutory compensation, which we can go into later. But the bottom line is that probate is very expensive and can add up to tens of thousands of dollars, even on a modestly sized estate.
And so a will lays out how a person wants their assets distributed. How does a living trust handle assets differently at death compared to a will?
Well, it's much different because a trust is a legally recognized entity. And the way that the law works is that it says when you put your assets into your name as trustee of your trust, it connects those assets to the instructions of the trust. And therefore, the people that you've selected as the trustees, those are the people that are designated to manage your assets and distribute your assets and take care of you if you were to become incapacitated, they can immediately step in without court involvement, without having to go through probate court, without needing that letters of testamentary, which is the court order giving them authority. They simply obtain a letter of incapacity from your doctor, and then they would go to the banks and your different financial institutions and show them that letter. And the bank is authorized by law to acknowledge them as the successor trustee and allow them access to your assets without worrying that they're giving access to the wrong person. Because the law says that we can follow the instructions of your trust if you fund your trust, if you put your assets into your name as trustee of your trust. And then after your life, the trustee would get a death certificate and they would go to the financial institutions or the escrow company, real estate agents, and they would show them a death certificate. And at that point, they would have access to your assets. And they then have this legal obligation called a fiduciary duty. And the law dictates what they have to do. And so the law says that everything they do has to be calculated for the best interests of the beneficiary. And that's the foundation of the law that makes this work. And the law goes into great detail about what the trustee has to do. And Basically, what they have to do is they have to be super honest, and they have to keep detailed accounting, and they have to be prudent and avoid conflicts of interest. Keep your money safe but diversified, and it goes on and on. But the bottom line is that no matter what they do, everything they do has to be meticulously thought out to be in the best interest of the beneficiary. And the beneficiary of the trust is the person who set up the trust. Those are the people who have all the rights and all the powers, right? And then after that person passes away, the beneficiaries are the people who are receiving the assets of the trust. So it works in any situation. During your life, you're the beneficiary of your trust, so everyone has to do everything in your best interest. And then after your life, the beneficiaries are the people that you've selected to receive your assets, so the trustee has to do everything in their best interest. See? So unlike a will, before anyone could do anything and take any actions, we have to go through this long probate process. And before you get approved as the executor, now in the will, they're called executors. In the trust, they're called trustees, but it's the same similar role. The difference is the executor has no ability to do anything until they get acknowledged by the court with the authority to handle your affairs, so to speak. And in the meantime, all the accounts get frozen, nothing can get paid, nothing can get sold, and it becomes very stressful on your loved ones for this waiting period. And so that's why a will is something that you don't want to rely on, and everyone should have a living trust in place.
And Cody, for a trust to avoid probate, what has to be done correctly during someone's lifetime?
That's very important, and that's what a lot of people don't realize. And I've noticed that even a lot of attorneys that don't do this exclusively on a day-to-day basis don't understand how it works in the real world. But what is crucial is that your assets have to be properly connected to your trust. It's called properly funding your trust. And what that means is that you have to put your name on your assets as trustee of your trust, and it has to list the name of your trust exactly the way that it states in the trust, and it has to indicate the date of the trust, because that's how a trust is identified. Like a person, we're identified by our name and our birth date. So if there's someone with the same name, we can distinguish that this is a different person because it's unlikely they're going to be born on the exact same day. And as you noticed, if your name's spelled correctly or incorrectly, then sometimes your banks and other agencies and third parties that you're dealing with will cause problems because they don't know that you're the person on the paper. See, if your name is spelled differently than it is in the accounts, then they kind of get skeptical. They don't want to get potentially in trouble giving access. So it's important that the titling of the assets is exactly as it appears in the documents and the exact date appears. And I've seen people where they put their assets in the trust and they put the wrong date, or they misspell things, or they forget a word, or they'll call it a family trust, and when the document refers to it as a living trust, and so on. So these things are essential. And once that occurs, that's what gives everyone else in the real world the authority, the permission to follow the instructions of the trust. And they don't have to worry about getting in trouble. And that is what avoids probate, because they're not going to make anyone go to court and get legally authorized with the permission to access our assets. Did that answer your question?
It does, it does. But it causes me to have a follow-up, and that is, in what situations might a will be sufficient? Are there any?
Well, a will can be sufficient if you have minimal assets. And what I mean by minimal is if you have no real estate and your assets are less than 208,000. And so if you have simply bank accounts you can name the designated beneficiary on those accounts, and the money will be distributed to those people. But what people don't realize, and from our experience of doing this on a day in, day out basis, is that if your assets aren't in a trust and they're just in your name, then those accounts get locked up. They get frozen for 40 days. It's a routine procedure. And they get frozen for 40 days. And that's kind of like a safety net in case you owe taxes or you have any kind of spousal support or things that need to be paid to other people. It allows everyone a kind of a cooling off period to be able to get their claims set before money gets distributed out to the named beneficiaries. Now, once the 40-day waiting period is over, then the people who are named as a beneficiary, presuming there are beneficiaries named, and then we've seen oftentimes people set up bank accounts, but they don't name a beneficiary. And the banks will always let you open bank accounts, but they won't require you to name a beneficiary. So if you overlook that and you never get back to it, oftentimes people pass away without beneficiaries named, and that causes a probate situation. But presuming there are beneficiaries, then the beneficiaries would go to the banks or whatever financial institution you're dealing with, and they would fill out some paperwork. And in a matter of a few weeks, the money gets distributed to them directly. And they have no obligation to use that money to pay for the person's final taxes, funeral expenses, credit card bills, and whatever financial obligations are remaining. So it leaves kind of a mess for people who are dealing with the final affairs of the deceased person, because there's always final taxes that need to be filed, credit card bills that need to be settled. Sometimes there's mortgage payments that need to be paid, and we can't access the money to pay for those things until the accounts are unfrozen. So oftentimes there's late fees for mortgage payments, credit card bills go unpaid and accrue interest and penalties, and it becomes a very messy, jumbled mess. So even though you may not have a lot of assets, it's important to have a trust to allow your loved ones immediate access to your assets before things are distributed.
That makes a lot of sense. And I do have one final question for this episode, and that is, can you tell us what tends to happen when someone owns real estate in California, but only has a will in place?
So that's where most of the problems arise. And that's why we make a big deal of putting the real estate into the client's trust for them. We'll handle that entire process on behalf of the client so that we can sleep at night, right? Because if we're just creating estate plans and sending you on your way, we're not doing a good job for you. So what we do is we educate people on the things that I've discussed, and we allow them to come back and ask questions later on, even years later. We'll come back and help them if they forget what to do. But the real estate is something that we don't leave to chance. Now, we can't do the financial accounts for you because, number one, the bank's not going to talk to us, right, without certain authority and documentation that we have permission to talk to your bank on your behalf. But the real estate we can do because those are public records. And so if you don't have your real estate into your trust, then probate is inevitable. Because you can imagine if there's one person that owns that property, or even if there's more than one person that owns that property, when the last person passes, the rest of the world doesn't know who's in charge of that property. And therefore, no one's going to sell it. No one's going to deal with it because they don't know who to deal with. They don't know who has the authority to sell the escrow papers. They don't know who has the authority to insure it. And so that means we have to go to court, probate court, and get someone legally authorized with the authority to manage that real estate. And again, that's what we want to avoid, because real estate is an expensive asset And probate fees are based off a percentage of the estate assets, which the law says the first 100,000, 4% gets paid to the lawyers and the executors. And the next 100,000, 3% gets paid to the lawyers and the executors. And then the next 800,000, 2% gets paid to the lawyers and the executors. So on a typical $1 million house, which is pretty common in California, the lawyers get paid $23,000 in what's called statutory compensation, and the executors get paid $23,000 in statutory compensation. So you're looking at $46,000. That does not include filing fees, putting the newspaper ad, postage, and all those other miscellaneous costs that go with going through the probate process, including appraisal fees. So all the assets eventually get appraised through what's called the probate referee, and they get 1% of that asset. So there's another $1,000 that goes to the probate referee. So that's another big reason. If you own real estate, you have to put it in a trust. There's no two ways about it. There's other, ways to transfer it, like a transfer on death deed, things like that. But those cause a lot of problems because it doesn't give anyone authority to deal with all the other stuff involved with owning real estate, keeping it insured, paying the property taxes. It just says, here's who gets it after my life, right? So it's not the best way to go. And the trust by far is the best vehicle to easily, efficiently transfer real estate to your beneficiaries and your loved ones after your life.
Thank you, Codi. We'll leave it there for today's episode. We appreciate your insights on wills and trusts today.
Thank you, Lisa. Nice to talk to you.
Thank you for joining us for Trust and Estate Clarity with Dada Law Office and Attorney Codi Dada. Please take a moment to subscribe, like, and share this episode with someone who needs to hear it. For more resources or to start your own plan, visit dadalaw.com. Thank you for tuning in, and we'll see you next time.
Thank you, Lisa.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.